It will come, no? Will come.
Serial number 14, my lord. We also connected matter is appearing. We are seeking for.
We called after 2 weeks. The matter wherein it then
We'll go to, please.
When do you want?
Any date on
Any date
after
next month.
February, my lord?
After February?
No, because the Supreme Court, the matter is seized off.
Or
Therefore, I think
not
it can be urgent. 6 weeks.
11?
In serial number 14, my lords, in last of the matters, there is an application, my lords, for modification filed by the state government. On the last date of hearing, my lords, they had mentioned the matter and it was urgent. My lords had indicated that only that application for modification of the interim order will be taken up. So that was the understanding, my lords. Now again, they have mentioned, my lords, without informing us.
In respect of East.
No, that is admission. It has now come up for admission. Virtually, it needs to be heard finally, my lord.
Lords, there is one application for modification in the last connected matter. It can be kept on the board.
On that day will consider.
Your lordship may kindly post it for on that day. Much obliged.
11.
11th March. Much obliged.
My lord, pursuant to the interim order, my lord, the workman was reinstated. And my lord, within 1 month, my lord, matter is listed, my lord, by that time workman not filed wakalat. The Honorable Learned Single Judgment allowed the writ petition and restored the award, my lord.
24th February. 24th. Yes.
My lord, one fresh matter for Monday, my lord.
Why?
They are putting up a illegal construction in CS site, madam. I'm a public, my lord. I have issued notice to BBMP also.
PIL.
Yeah, please, my lord.
PIL.
Please, my lord.
24th February.
My lord, Monday.
Monday. No urgency.
My lords, fresh matter,
Anything?
my lords, the deputy commissioner has recommended lands to be deleted from deemed survey list, my lords. That is not being considered and my mining activities have come to a halt, my lords.
Dated from deemed survey.
Deemed forest list. My mining activities have come to a halt, my lords. Some urgencies there, my
13th.
please, my lords.
13th February.
My lords, there is one more writ appeal filed against the same order. Could I request my lords to tag along with that?
Or little loud.
Lords, serial number 9, my lords, against same order, one more writ appeal is filed by the other respondent. Could I request to be connected with that? And
Today will issue notice in this 247 days delay.
sorry, please.
Notice returnable on 20th March.
Serial number 30, my lord. Requesting for next week, my lord.
In delay conduct. Yes.
Serial number 30, I'm for the appellant, my lord.
Serial number
30,
13
30, 30, 30.
30. Yes.
I'm happy for the appellant, my lord.
For appellant.
Requesting for next week, my lord.
Next week is not possible. The 21st March. As requested by Lona.
Serial number 1, your lordship.
1.
Yes. Seek a short accommodation if the matter
Hello,
can
sir.
be adjourned.
I'm filing my compliance affidavit in that matter. The matter can be disposed of.
We haven't been,
I'll reserve it.
So first,
In-
so copy to your learned friend.
I'm sorry, my lords.
Yes.
your lordship, we seek a short accommodation to go through the compliance
Covered
affidavit.
by judgment, my lords. There was allegations of deviations from the sanction plan. And we have issued the provisional order and the confirmation order in this aspect. The deviator has gone on appeal before the chief commissioner. The matter is stayed there and is pending. On a similar matter, my lords, this court has held that the contempt proceedings has to be dropped.
However, your lordship, we seek a short accommodation to go through the compliance affidavit.
Letter. 11th at 2:30.
Yes, your lord.
Tuesday, next Tuesday at 2:30.
Next Tuesday, it's okay, your lordship. Okay, your lordship. Obliged.
Contempt compliance affidavit may just pass on. Grateful, my
Any other mention through VC, sir?
Lord, serial number 15. Serial number 15. ma'am.
Serial number
Respondent number 6, 15.
15.
Respondent number 6 died ಆಗಿದ್ದಾರೆ. ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 6 ತೀರ್ಕೊಂಡಿದ್ದಾರೆ ಮೈಲ, ಅದಕ್ಕೆ ಮೆಮೋ ಸಲ್ಲಿಸ್ಬೇಕಿತ್ತು. ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 6 ಡೈಡ್ ಆಗಿದ್ದಾರೆ, ಎಕ್ಸ್ಪೈರ್ಡ್ ಆಗಿದೆ.
I am for the petitioner, my lords.
Not served, not served.
He stays.
137.
T. Sheshagiri for,
Yes.
so what is the request?
ಮೆಮೋ ಸಲ್ಲಿಸ್ಬೇಕಿತ್ತು.
What is the request, Mr.?
ಮೆಮೋ
What do you want?
ಮೆಮೋ ಕೊಡಬೇಕಿತ್ತು ಮೈಲ.
Memo?
Submission of memo.
May I,
Reporting the death, my lord. Memo
May I, my
reporting
lords?
the death of respondent number 6.
Memo of death of.
Reporting the death of the.
All right, take steps, since learned, since
First time.
memo is tendered, pointing out about the death of respondent 6, necessary steps shall be taken by the appellant. Tendered to 1st of April. No. 15. 1st April. Yes. Okay. Yes,
Serial number 43, my lord,
43.
cost list 1. We are filing memo for withdrawal of petition. We are for complainant.
43. Learned advocate. What is the good name?
Respondent has refunded the amount, my lord. But
Learned advocate, Miss.
my lord,
So and so for learned advocate, Mr.
we are for complainant, my lord.
Give your name. Kamath. Tenders memo. Withdrawal dated 7/2/24. Stating that the respondent has refunded the principal amount of ₹1.
My lord, we reserve liberty for the interest on delay to file in appropriate court.
1 crore. The memo is taken on record. Contempt petition is dismissed as withdrawn. Sorry.
Sorry, my lord, kind permission. One writ appeal is filed, my lord, against the no confidence motion. The first single bench has fixed the date on Monday, my lord. And actually there is a SC/ST case is pending. And it is a resignation was given under the threat. That was not considered and no investigation is being made. And writ petition is disputed. And the no confidence in meeting is fixed on Monday, my lord. Monday. So maybe permitted to move at 2:30.
Appeal,
Please.
2:30. When the order was delivered?
Order, yesterday it is released, my lord. 31st was the order. Yesterday a copy was released. We filed today, my lord.
Monday.
Monday,
Monday at 11.
please. Monday.
Subject to removal of office of.
Pardon.
Subject to removal of all office of this. It is writ appeal.
Please, please.
Yes.
But
I'm sorry, my lord.
25. Writ appeal 1037 of 24. Not to be placed before the bench where one of us. Mr. Justice Samayaru
May I make a request? I'm sorry, not in this.
is a member, yes.
But in the serial number 15. Serial 15, not the respondent is dead. They have reported the death. I am just now, I have made filing wakalat for the LRs. I have some urgency, my lord, because
Then you
posted
want,
to 15.
you want earlier.
Yes, ma'am. Posted to April.
Inform the other side, will recast the order.
Yes,
But it was stated by learned advocate for the petitioner, the respondent 6 says, right? From a learned advocate, Mr.
N.K. Ramesh.
N.K. Ramesh appeared to state that he would be appearing for the, but heirs are
Respondent.
Respondent 6.
Respondent 6. Legal heads of respondent 6. He is no more.
they are joined,
Yes, ma'am.
heirs are joined.
No, filing wakalat the first time.
But where is the parties must be there? They are joined.
No, no, they're not joined.
Number 6 has died.
Yes,
So
he
the
died.
legal representatives have to joined as party.
No, not yet.
They
my
were
lord,
not
not-
joined. I'm not filing wakalat for him by impleading. They have not made
Where is that application?
application. The application is ready. my lord.
Filing, no? Application for impleading is filing.
Yes.
So is filing the application for impleading the heirs. And that would be appearing for the heirs. Also, the impleading application may be listed on 18th of February.
Please, oblige.
Then on that day we fix the
Yes,
appeal in present.
yes. Petition.
Inform the others.
Yes, I'll inform.
And permissions. Number 2, contempt. K.R. Lingaraju.
To appear for complaint, my lord. Annexure A is the order of the Karnataka Appellate Tribunal, my lord. The Karnataka Appellate Tribunal had granted stay of maintenance status quo in respect of order Annexure A, my lord, page 24, my lord.
What is the date of the order?
My lord, date of the order is on 9/10/23, my lord. 9/10/23.
When the
The entries have changed on 6/11/23, my lord.
or learned advocate. So I'm sorry for the petitioner. It is not only time barred, but it is also entry mode.
Entry mode
K.R. Lingaraju for the complainant and learned additional government.
for the
advocate.
respondent.
Full stop. The contempt is alleged in respect of order dated 9/10/23 passed by the Karnataka Appellate Tribunal. Full stop. On a bare perusal of the order, it becomes clear that the order was passed on 9/10/23 and the contempt petition was filed on 19/12/24, which was after 1 year from attracting the bar of section 20 of the Contempt of Court, section 1971, by very nature of the order, which is admittedly an interim order, the same does not crystallize the rights of the parties finally. Full stop. The interim order therefore would not be on both the counts above, the contempt jurisdiction is not liable to be exercised. The court is not inclined to entertain the not let the exercised, the contempt petition is dismissed.
My lord, there's delay of 74 days.
No delay, it is barred by time. Concept of delay doesn't come. Section 20 says that after 1 year you can't file contempt.
My lord, the facts of change of entries, my lord, it's not within the knowledge, my lord.
Then it is interim order, this court is not entertaining any
My-
contempt.
My lord, what happened, my lord, if,
The trapping of any finalities. Finally something is
my
decided.
lord, if, my lord, what happened, my lord, if entries are changed, my lord, if any third party interest have been created, my lord, it's affect the interest of the parties, my lord. My lord, from the date of knowledge of,
Be open for the petition to work out his rights and remedies before court where the parent proceedings are pending.
my lord, with knowledge of order of KAT, my lord, the respondent number 1, DDLR, my lord, assistant, my lord, is changed the revenue entries, my lord. My lord, insofar as delay is concerned, my lord, after knowledge, my lord, without doing any delay, my lord, I
Forget-
caused the notice, my lord.
Forget delay because interim order we are rejecting. Next.
Green bench matters. Number 3, Mr. Mahesh Kiran Shetty.
Yeah, here for the petitioner. It's a matter wherein I being the absolute owner of the
Who is
property,
number 5?
my lord, respondent number 5 is a private respondent.
Your tenant?
Yes, my lord, he is my tenant.
So then
My lord, in this matter, what has happened is I have leased out the premises on the condition that, my lord, he shall discharge the stream water drain through the proper mechanism and scientific way in consonance with section 24 of the Water Act. My lord, even the respondent authorities who have inspected the spot, they also come to the conclusion, my lord, that he is not doing it in a scientific manner and he is discharging the stream water waste into the agricultural property. The photographs, my lord, which wherein I have produced B series, annexure B series, indicate that, my lord, the entire waste, which is even, my lord, the toilet waters, the other waste, is discharged into the agricultural properties of the petitioner, against which, my lord, I have given the complaint, they have inspected, and they have also come to the conclusion that, my lord, there is discharge of wastewater without scientific manner. And instead of taking action, my lord, they have been communicating among themselves. If your lordships could kindly, may I take your lordships to annexure E, my lord, page 56. The typed copy your lordships would find at page 57. With regard to disposal of hotel waste, with reference to the above subject, as per the above reference, complaint is received in this office by the applicant. And in the hotel business which you are running, all types of wastewater is not disposed by you scientifically and is letting out the wastewater into the agricultural lands belonging to the applicant. And in view of this, it is causing trouble for the agriculture. And in this regard, as per the reference, the spot inspection is being done and the disposal of the said wastewater scientifically prima facie is not being done. And hence, in this regard, within 30 days of receipt of this notice, in your hotel industry producing wastewater to be disposed in the proper manner and submit the report. Failing to do, further suitable action will be taken. My lord, in spite of that, he continues because the photographs which I have produced are the latest photographs. Till date, my lord, the same position is continuing. And respondent authorities, even though issue the notice to them, they doesn't take any further action for violation and non-compliance.
The hotel.
It's a hotel. It's a hotel and the entire wastewater as well as the waste is discharged into the agricultural property as well into the main road also.
You can approach the board, pollution control.
My lord, there is a reference with regard to.
Unless they approve, you need not stand up. Sit back.
May I request your lordships to kindly look into page 57 itself.
Are you appearing? Then welcome. Are you appearing? Are you appearing in this matter?
I have to take notice, that's why I was
Still
notice
not-
was not issued, that's why I was sitting.
Wait. Take your seat.
May I request your lordships to kindly look into page 59. Page 59, my lord.
You can go before the board which is here.
For that, I may be permitted to make one submission.
The pollution control board is very near to you.
That is true, my lord. My lord, pollution control board also enters into this matter and they also say, page 59.
This is a landlord-tenant dispute and that you are.
My lord, if at all it was a landlord-tenant dispute, I would have sought for an ejectment suit. My lord, that is not my case here. My lord, I don't want his business to be shut. I want him to, my lord, follow the procedure, the STP, whatever is has to be done. In accordance with that, my lord, he has to conduct his business. Page 59 may kindly be looked into, my lord, for a moment. May I persuade your lordships? Page 59. In the typed translated copy at page 60. The subject in that serial number 3, Environmental Officer, Karnataka State Pollution Control Board has also written a letter to the Taluka Panchayat there. My lord, they are aware, my lord, we have also given a representation to the board. Board in turn writes it to the Jilla Panchayat and Taluk Panchayat to take appropriate action. Page 60, my lord, in serial number 3, in the subject, Pollution Control Board has also written a letter.
Heard learned advocate Mr. So-and-so for the petitioner. Full stop learned advocate Miss Vaishnav. What is your good name?
Rishika Vaishnav, your lordship.
Rishika Vaishnav appears in course of the hearing to accept notice on behalf of to submit on to represent respondent number 1 and 2. That's the Karnataka State Pollution Control Board and its authority and the district Both you are aware,
District and state pollution control.
and the district pollution control board, who do? The prayers advanced in this petition, filed under Article 226 of the Constitution, is to direct the respondent 1 and 2 to take steps against the respondent 5. Private respondent 5. Charge of polluted water, which is generated from the hotel run by respondent 5. The petitioner wants that the action in law should be taken against the respondent 5 under the provisions of the Water Act and the Air Act. Water Act for discharge of effluents. The petitioner also wants to cancel. Also wants this one 3. The Saligram SALI Town Panchayat to cancel the trade license. Of respondent 5. The case in the background, as pleaded in the petition, is that the petitioner happens to be the owner of server number 40-35, head measuring 34.5 stands, which is a land converted for commercial purpose. Full stop. The petitioner executed lease agreement in care of respondent 5, which is a lease for 20 years, commencing from 16/11/2017 to 15/11/37. The possession of the property is the state respondent 5 in capacity of lessee, where the where respondent 5 has been running hotel. Full stop. The allegations are made by the petitioner landlord, wherever. In respect of the alleged, and in respect of by the petitioner landlord, that the tenant is discharging the filthy and waste water directly to the property of the petitioner, and thus causes stagnation of waste polluted water in the private areas, which results into foul smell and further results into embarrassment and inconvenience to the general public, including the petitioner. Full stop. The relationship paragraph between the petitioner and respondent 5 are that of lesser and lessee. Full stop. The full stop. Respondent 5 has been running hotel in such capacity on the land of the petitioner. Full stop. The dispute sought to be agitated in the writ jurisdiction. Though must differently, basically and prima facie appears to be a dispute between the landlord and tenant. The courts therefore is not inclined to entertain the petition, nor inclined to exercise its extraordinary jurisdiction under Article 226 of the Constitution. However, while dismissing the petition, liberty is reserved for the petitioner to approach the pollution control board if advised. Such eventuality, the pollution control board shall act in accordance with law. That's it.
Right. Instead of saying dismissed, my lords may kindly say that while disposing of this petition, liberty is reserved, because
Subject to limited liberty given above, where the subject to limited liberty given, subject to above limited observation, the petition is thoroughly meritless and it is summarily dismissed.
Cell number 4, Mr. Raghavendra G. Gayatri.
Yes, Mr.
Appear for the petition. It's deemed conversion for under 95(9). my lords. Deemed conversion under 95(9). I have filed the representation which is not considered.
Similar order.
Similar.
Where is that order? It is also annexed.
My lord, page 15.
Oh, same.
Yes.
Or learned, so for the petitioner and learned additional government, who appears to assist the court upon service of copy of the petition in advance. Displayed paragraph in the petition is to direct the respondent to consider the application dated D-12 of the petitioner and to communicate the amount of fine payable for conversion of land into agricultural purpose, non-agricultural.
Non-agriculture purpose.
In accordance with Rule 107 of the Karnataka Land Revenue Rules 1966. Full stop. It is spread. What is the other application? 59.
Annexure H, my lords, for 95(9).
It is
And-
further prayed to consider the application wherein the petitioner is sought for deemed conversion in terms of provisions of subsection 9 of section 95 of the Karnataka Land Revenue Act 1964. Full stop. Paragraph. The petitioner are the, as for the case of the petitioners, they are the absolute petitioner or petitioners
Father and son, my lords, petitioners.
are there. Petition, as per the case of the petitioner, they are the absolute owner of the land survey number 51/1, situated at Balligeri village, Pathani Taluka, Belgavi district, at measuring 19 acres and 8 quintals. Out of the said land, in part of the land, the petitioners have established the stone crusher unit and have been carrying out the quarrying activities. Full stop. An application is made on 15th August 24 and 23rd August 24, seeking from the competent authorities a deemed conversion under the provisions of the Karnataka Land Revenue Act 1994. More particularly, section 95 and Brigade 9 of the Act. Paragraph. In course of the hearing, Karnataka Land Revenue Act 1964. In course of the, not 90. In course of the hearing, learned advocate for the parties had no dispute in submitting that the prayer at petition, the prayer of the petitioner deserves to be disposed of on the same lines as per order dated 16th January 24, passed in Vimati Chandrava Anamant Mada MADR and others was State of Karnataka, which was read petition number 34549 of 2024. For seeking consideration of the request for conversion and deemed conversion under the provisions of section 95 into Brigade 9 of the Act of 1964, the petitioner has shown his readiness and willingness to pay the amount of fine as may be determined by the competent authority. In light of above, present petition is disposed of with following directions. So which is your date of application?
Milords, 95 on 15/8/2024 and fine amount on 3/12/2024.
Both, both.
23/8.
15/8 annexure F.
Have the date of application.
Deeply obliged.
Obliged.
Five, so writ appeal, Mr. R.G. Hegde. Number 5. Number 6. Mr. Nandita D. Aldipur.
Appear for the appellant. In this, we have challenged the para 83, quashing of para 83 of the Employees Provident Fund scheme.
Notice returnable.
I
The
take notice
connected
by
matters are
respondent number
posted on 18th February. Your Lord.
18th February.
obliged.
Number 7. To Naveen Jain.
Notice returnable on 14th March.
Number 8.
Delay.
To Aditya Narayan.
Not to be placed in bench.
Milords, in this matter,
Milord.
Milords, the
Comprising of duplicate my name.
Milords, in serial number 8, I'm seeking an interim order. Milords, in fact, Mr.
Next.
Raghavan's leading me in this matter.
Milord,
Milords,
I-
there's a direction. Milords, there is a direction.
The order or not?
I'm sorry, Milord.
You listen to the order or not?
I'm
Not to
afraid.
be placed before this bench.
Oh,
Yes, next.
Milords, may I request your
Number-
lordships to kindly direct it to be listed before any other bench, Milords, on a short date.
Milord, I just received the IA today.
The register
Obliged, Milord,
has
I'm sorry.
request- Yes, next.
9 is adjourned. Number 10. To Nayak Innar. Number 10. To Nayak.
I beg to appear for appellant Mela, 3 days delay Mela. For getting translation, my lord, all the papers there is a delay in 3 days, my lord. Kindly may be condoned.
3 days delay, notice returnable on 17th March.
Please.
Seal number 11. The state appeal.
Milord, I appear for respondents.
Serial number 11. Yes, okay, sir.
My lord, these writ petitioners, my lord, they were appointed to the
Now-
post of craft teachers, my lord.
Craft teachers,
Craft teachers, my lord,
2000,
by the respondent number 4 and 5 educational institutions.
2008.
The rules came into force on 2/2/2000, my lord, the rules of 1999. The rules at the original instance did not provide for the post of craft teacher at all, my lord. There was no post of craft teacher as per the staffing pattern. Thereafter, my lord, 2007, my lord, a craft teacher's post was included. In 2016, my lord, it was again deleted and there was a saving clause which said that those who have been appointed and granting aid has been granted, they will continue till they attain the age of superannuation or death, my lord, or removal from service. Therefore, prior to this rule came into force, my lord, there was no post that was created. And there was no granting aid also granted, my lord. All these writ petitioners, my lord, have been subsequently appointed by the institution and the government has not extended the benefit of aid for them. For the reason the appointment, they were not appointed in the institution prior to the cutoff date of 2/2/2000. That is the date on which the rules came into force, my lord. On this ground, my lord, a condition was imposed. While other staffs were considered for admission to grant salary, writ petitioner's case was rejected, my lord, for the post of craft teacher.
They were appointed in 2008.
They were recommended by the institution, not considered by the government, my lord, for grant aid.
They have been continued.
My lord, they were continued by the management. Grant aid was not extended by the government. My lord, in an identical case, my lord.
Your contention is, see, the amendment to the rules happened in the year 2016.
Please, my lord.
And anybody appointed prior to 2016, if they were already admitted to grant-in aid, then they would continue in that post till their superannuation.
No, my lord. Prior to 2000, if they were appointed, they can, please.
Okay, but in the case of the petitioners, though they were appointed by the schools prior to 2016,
please,
their posts were never admitted to grant-in aid.
Correct. Correct.
Correct. So prior to 2016, they were not eligible to grant-in aid.
2016, my lord, the post of craft was removed, my lord. It was omitted.
That's
it
what
was introduced in 2007 and omitted in 2016.
Exactly. They were appointed after 2007.
Please, my lord. Please.
Okay.
Please.
But they were so appointed by the school's consent.
Please. Please, my lord.
And that post was never admitted to grant-in aid by the state.
Please.
Though submissions were made by the consent schools.
Please.
In the meanwhile, you came up with 2016 order.
Please.
And you removed that post itself permanently from grant-in aid.
From 16 and onwards.
From 16 and onwards.
Correct. My lord, while granting the grant salary, my lord, while considering the case, the cutoff date, my lord, we have considered is the date on which the rules came into force. That was on 2nd February 2000, my lord. Those employees who were employed prior to this cutoff date by the institution, they were considered for grant aid under the 2007 rules. So 16, they were removed. All these people were subsequently been appointed by the institution. There was an identical case, my lord, of the learned single judge, where he has taken a different view, my lord. It's a policy decision of the matter. I'll just pass on, my lord, because it's an identical case of craft teacher under the same rules. I'll just pass it. Page 5, my lord, the contention of the government appears is recorded in page 5, my lord. There are no paragraphs as such, my lord. Page 5 may kindly listen.
So last year is name. Could again become feasible.
But your lordship, they themselves, my lord, admitted the post is entitled for granting in para 3, your lordship may kindly see. Appeal memorandum. Appeal memorandum, para 3. It is submitted that as on the date they were appointed by the private aided education institution. The amendment brought on 16/6/2007. No doubt was holding the field. The said amendment tools provided for the craft teacher to be admitted for salary granting aid. According to their own admission, my lord, my post is entitled for salary grant. My appointment was made subsequent to the amendment rules in 2007. My appointment is perfectly valid. The other teachers have been extended, my lord, the grant.
Only ground, my lord, they say, only ground for rejection is, I was appointed subsequent to 2000. That is only the ground for rejection, not other grounds. That is annexure 108, your lordship. This. Page 108, my lord. Condition 3. As the post of professional teacher, my lord, it is a craft teacher post, are filled on 16/1/2008. Therefore, they are not eligible to receive the financial aid. That is the only ground, man. That ground, my lord, they have rejected, completely ignoring, my lord, the amendment brought subsequently in 2007.
16.
2007.
2016. Amendment is 7.
No. My lord, the post was included, my lord, 2007 again. As per annexure A. My lord, annexure A, your lordship, my is it. My lord, prior to 2000, the post was admitted, my lord, the admitted to this traffic pattern. From 2 to 15/6/2007, it was omitted. Again, the post was included by annexure A.
Appeal is admitted. State for final hearing on 16th April.
This.
Still number 12.
Lordship is admitted. There's an interim order sought.
12. Oh, yes, delay is gone.
Zero.
You now give Can make submission, yeah, statute. Initiated action, amnesty.
You are for appellant. In till number 11 or 12?
14% is okay.
11.
Is it?
Is it 11 or 12? 11.
Serial number 12, my lordship.
11. No, 11 was that salary grant. Now we are on 12. How come? This 11 was retouple 7 for.
Is it tenant?
The previous matter, my lord, if lordship is admitting the previous matter, my lord, I have requested for stay of the operation of the judgment, my lord. That's what.
The other side.
Because, my lord, there is a direction to implement it, my lord.
Call him at 2:30.
Please, my lord, I'll inform.
So appeal is admitted since the court is seized of the subject matter controversy, there shall be no, the directions of learner single shall remain in abeyance.
Grateful.
Pardon, admit. Is it reserved, my lord? Matter.
Admitted.
Still number 12.
I'm the
Pravina
petitioner.
Kumari, party in person.
Yeah, I'm the petitioner, my lord. And Uh,
BBM.
Yes, already initiated action, my lordship, 248, 1 and 2, my lordship. Already initiated action 248, 1 and 3, my lordship. Thereafter, the respond number 4 approach before the chief commissioner, which was dismissed, my lordship. Then the approach from this, so this court has already granted stay. So already proceeding, all the action is taken, my lordship. 248, 1 and 2 already have taken action against the respond number 4, my lordship.
I am the necessary party in this case, my lord. Based on the complaint and information furnished by me, BBMP started the proceedings and issued notice for demolition. The building in question was constructed between 2017 and 2019. BBMP has had plenty of time to prevent the construction, but it failed to do so. For any building, the following are essential: land conversion or BBMP Khata, sanction plan, occupancy certificate. But the present owner does not have any of these mentioned. In the case of Shankar Rao versus Jagan Mohan Reddy, former CM of AP, the High Court of Andhra Pradesh permitted Sri Eram Naidu, the TDP person, to implead in the case. And also in the case of Mr. Raghuram Rajan, the former MP and present MLA of Andhra Pradesh, was allowed to implead in the case between the government of AP and the police department. I request humbly before this court to allow me to implead in this case. Sorry. Thank you, my lord.
My lordship, the list is between the BBMP and the private party. That is the statutory authority has taken action against the alleged illegal construction made by the respondent number 4, my lord. Your Honor, my lordship, my kindly, when the statutory body is initiating proceedings in accordance of law against any deviation in the building, her presence is not required, my lord. Then she is the only reason, my lord, she is a tenant, she is a due in a sum of rupees more than 5 lakhs as on today, without paying the rent. But she has made a complaint. We cannot make any allegation against the issue, filing a complaint to the BBMP, my lord. The list is only between the BBMP and the private party. That has taken action has been taken by the authority, my lord. The present petitioner is not required in the proceedings, my lord. I have relied upon a decision of this honorable court, my lordship. It is aptly applicable to the present case on hand, my lord. May I read, my lord? Based on this judgment, my lordship, she is not required necessary party in the proceedings.
That's all. Anything for you want to submit?
No, because it is not necessary party.
There or you separately.
I am for the
He
respondent.
is the respondent for, my
He is for
lordship.
BBMP.
BBMP, my lordship. Already
The owner
initiated
of
action,
building.
my lordship. This court has already granted stay, my lordship. We have already passed 356 no demolition order, my lordship. Already this court has stay the proceeding, my lordship. Therefore, you are waiting for the writ petition, my lordship.
Is there a party to be implemented or not?
Not necessary party to the my lordship. She is a third party, my lordship. She has no right to decide of
Is all, anything you have to submit, Mr. Party in person?
Yes, my lord. This complaint is raised by me with the BBMP. And it took 3 years for me also to initiate the actions from their side. And the building is constructed between 2017 and 19. And now in their statement before the appeal BBMP, they mentioned that they have obtained the partition deed and all after giving the building to the tenants. So they have BBMP failed to question them. So, and also they gave a wrong impression before the single bench judge that the sanction, it is a deviation of sanction plan, but they don't have any sanction plan itself. I have submitted the letter from the concerned authority that they don't have any sanction plan, and I submitted before the BBMP commissioner on the day of appeal. So it is like deviating from the matter also. If you look at the orders of the single bench judge, I also mentioned in my application. So I can, if I am allowed, I can be able to put forward the findings which I have collected from various government offices before the court, so that court can take a helps in court taking decision. Thank you, my lord.
So order will be declared on 13th of February. List and 13th of February, 2:30. For declaration of order. Simply to be listed. Simply stand over. Not for pronouncement, not.
Serial number 13.
Serial number 13, my lords, is a state writ petition. Writ appeal, my lords. My lords, matter relates to, my lords, appointment to the post of guest lecturers in the Department of Collegiate Education. My lords, we have three categories, my lords. One is lecturer or assistant professor, my lords, who is a regular direct recruitee. Then we have got what is called as a contract lecturer, my lords. Then, insofar as workload is concerned, we have what is called as a guest lecturer. Under the UGC regulations, my lords, insofar as a regular lecturer and for a contract lecturer, there is minimum qualification that is prescribed. Insofar as guest lecturer, my lords, there is no such qualification prescribed. In the earlier round of litigation, this honorable court had considered, my lords, and directed the state government to consider whether guest lecturers can be continued, my lords, in the light of UGC regulations. On the basis of that, we have taken a policy decision and continued. Now, my lords, we require under now the learned single judge operative portion. It is page 58, my lords. May kindly see, my lords, operative portion, page 58. The writ petition is allowed in part. The respondents number 1 and 2 are directed to ensure complete compliance of the minimum qualification as prescribed by the UGC. Respondent number 3 under the UGC regulations 2018 before selecting any lecturer candidate for the post of guest lecturer. It is made clear that in view of
This is somewhere in March, 10th March.
Lords, there is some urgency, my lords. What has happened is we are short of, my lords, hands. Around 10,000 guest lecturers are required. My lords may actually permit us to comply with the order of the learned single judge.
10th will give.
Please,
10th of March, next.
please.
My lord, my submission is that, my lord,
On 10th of March, what we will do? 14th is already at.
My lord, this is a public interest litigation that was filed against arbitrary cutting of trees in a park. The reasons given by the authorities are not sufficient, my lord. Initially, they said they needed to cut 50 trees to widen a stormwater drain. That arbitrarily increased to 60 trees and then 73 trees. There's an interim order of status quo that is in operation. They're yet to file their objections, my lord. My lords will find the impugned order at page 60, Annexure G. Out of the 73 trees that were sought to be cut, 30 were ordered to be retained, 1 was ordered to be transplanted, and 42 were ordered to be felled.
What is the grievance?
My lord?
What is the grievance now? The committee has already granted permission.
The status quo is in operation, my lord.
No, no. As per page 61.
Yes, my lord.
Annexure G.
Yes, my lord.
The tree committee has granted permission.
This is against the permission that has been granted.
Correct. What is wrong in the permission?
The permission that has been granted in a mechanical and non-scientific manner, my lord. It is my contention that there has been no inspection that has been carried out. They say that they're cutting trees on the basis of representations received from the public. There is no such representation. In fact, there is a signature campaign by all the residents around who say that please do not cut these trees. They are,
PVM. Please enjoy the relief. We'll keep it on 12th of March,
obliged.
since nobody is here. Yes, next.
My lord, the interim order may kindly be continued, my lord.
Is it limited?
It is still the next date of hearing, my lord.
Interim order granted on 20th for 23 shall, and which has remained in operation, commercial continue to operate till the next date.
Obliged.
So number 17, to Jay Prakash Reddy M. Number 17, number 18, is Suhani Ola.
What is to be done?
My lord, I have filed a memo, my lord, which is dated 22/11/2024, bringing to my lord's notice that the state government has no objections, my lord, for the writ petition to be allowed. This is with regard to, my lord, the strict implementation of the provisions of the emblems and names.
Where is your memo?
My lord, it's dated 22/11/2024, my lord.
21, 21/2. That is memo of appearance. There is no such. It is not there in our record.
It's fine. Then I'll file another set, my lord may have it.
March, 19th March.
Obliged.
To number 19, Sir Ravindra Gajaram Pillai.
Please, my lords.
My submission, my lords. I was granted a query lease for 25 acres of extracting sand downstream river Tungabhadra, valid for a period of 5 years, my lords, with a condition stipulated that I need to extract 50% of the designated quantity every year. During the period of COVID, my lords, for 1 year, I could not complete the target. And Rule 31 5 provides for condoning such lesser quantity extraction beyond control of the petitioner, my lords. That I may kindly be permitted to read Rule 31Y, my lords. Proviso attached thereto. Y.
Even why?
31 capital Y, the heading is minimum production and dispatch requirement. Subrule 1. And relevant portion is proviso attached thereto, provided that where the failure to achieve minimum production and dispatch requirement is for the reason beyond the control of the holder of lease or license, the competent authority on an application made by the lessee or licensee and after giving an opportunity of hearing may waive the requirement of minimum production and dispatch for such period. It's during the period of 5 years, my lords, I had extracted or I have complied the condition for first 2 years and last 2 years. In the middle 1 year, my lords, first 3 years and last 1 year. The 4th year, I could not achieve the minimum production target and dispatch, my lords. That is because of COVID pandemic.
Will file reply. Notice to the respondent returnable on.
In the meantime, my lords, the quantity stored in the stockyard, let them not dispose, my lords. That's only my limited prayer, so that let it not somebody else misuse the
What is the material?
Sand, my lord, sand. Sand.
Ordinary sand
Sand.
is in the stockyard, my lords. Just because it is being misused, because it is unfenced.
Notice returnable on 6th of March. You are here or not?
Yes, ma'am.
6th of March. Before next date, the reply shall be filed by interim order. It is directed that the stock of the sand shall not be removed by this point.
Please, my lord.
Till the next date. It is already full stop. Heard learned councils. Notice was received in the petition on 19. Notice was received in the petition on 19/9/24. The reply is awaited. Full stop. Heard learned over to the parties with regard to interim relief. Full stop. In the facts of the case, the respondent shall not remove the sand which is lying in the stockyard of the lease site. Lease stockyard.
Stockyard.
Stockyard of
Of the petition.
My lord, may I make one submission, my lord? My lord, the date of order may be seen, my lord. 8/8/2024. The writ petition is pending before my lords.
Then you have removed so far.
No, I have no instructions with regard to that. On 5th, when my lord has posted the case, I'll make a submission with regard to that. So far, they have not asked, and I don't know what has happened.
We have made, because on 19th August 2024, we have filed this writ petition.
Maybe,
What-
but they did not insist for an interim order. My lord is having it on 5th. I will place before my lords what has happened. And today I will see that, my lord, it's not precipitated.
So I
And
would,
before my lords, I wouldn't want to violate whatever my lord has said.
So they are not removed so far. Notice was issued early.
Yes, my lord. I have not removed.
By
It is
fifth
still
will go
there.
hearing, fifth of
5th, I will.
The thing is, I am worried about the third party people taking away still delay. That's what I would like to.
My lord,
that, how can we monitor? Third party, how can we monitor third parties?
So, because if I will put watch and
my
watch.
lord, I'm sorry, let him file an affidavit to that effect that it is being stolen stealthily. There is nothing, whatever that is. I will meet that contention.
It is not within the quarry lease area. It is in private land which has been designated as a stockyard by the department. Department doesn't have control over that area, my lords.
How can we have control of department?
My only thing is let the status quo be maintained. That's all, my lords.
You file your reply early.
I'll file, my lord. I'll file by the 5th.
27, 27,
Very.
27.
Please, ma'am.
10.27 before it time. Before which date learned additional government advocate shall file reply.
Till number 20. The RKGMM Mass Swamiji, party in person.
Let's. IA 2 of 25, my lord, for amendment. It may be permitted to delete the alternative prior made in the writ appeal, my lord, seeking expansion of adversary.
My lords, this matter
IA
was
2 of
originally
25.
ordered to be listed on 24th of February. Filed an application seeking early posting of the matter. That's listed today. We have no objections for early listing.
Early posting. Why?
My lord, IA 2 of 25
What is it?
for amendment, my lord. It may be permitted to delete the alternative prior made in the writ appeal, my lord, seeking deletion of or expansion of adversary, my lord. It is necessary and inevitable to me to delete it, my lord. It will not prejudice the other side, my lord. And it will not cause hardship or irreparable loss to the other side, my lord. It is necessary for me to delete it. It may be permitted. It is alternative relief.
All the interim applications shall be considered along with the writ appeal.
IA 2 of 25, my lord.
When the appeal is heard.
My lord,
Together all together, not in piecemeal. Yes, next.
25, my lord.
Next.
Till number 21. The Rahul is ready.
Respond
Yeah,
number
for the
5 and 6.
Petitioners in this matter, my lords. My lords, may recollect this matter, my lords, the public interest litigation, wherein, my lords, a property, my lords, in the year 1956 was gifted to the second respondent school.
It is kept for orders. It is dismissed.
Much.
My lord, the government land. My lord,
So dismissed. Heard. Next.
Till number 22.
appear for the complainant.
Why shall
In
it
this case, I had requested on the last date that an SLP is
What
preferred.
happened to SLP?
My lords, sir, because of some verification, it was not listed next week. I just spoke to the council in Supreme Court. They said next week it is likely to be listed.
It is still in dairy number. It is not even numbered as SLP as of today.
I agree to that, my lords. There has been some verification which has been
In
happening.
fact, your lordships noticed this of about SLP in the earlier order itself, my lords, on 17/12/24. And gave them 3 weeks.
May request only 10 days accommodation, my lords. A date may be fixed. We'll get back to my lords.
The order dated 17/12 at para 5.2. And 6 and 7 minutes. It was noticed at that point itself. I leave it.
We'll change. We have filed it on 21/1, my lords. There has been some office objections which are being complied.
You do it, you're not, this is again 1 month.
Request a 10 days accommodation, my lords. They spoke to the council in the morning. They have completed all the verification on 5th of January, 5th of February.
Twenty-seventh.
Grateful.
Number 23. Mr. Sharat Rogi.
I am appearing on behalf of the accused. I have filed my Vukalatama in the counter. And my lord, I have already filed one WA1 writ appeal, which is posted on 24. Against the whatever the contempt, the order, whatever the past, I have challenged the order and which is posted on 24 in this month. So kindly be posted this matter connected with this appeal.
May I make a submission, your lordship? The contempt is filed for the renewal of minor child's passport, your lordship. Child is US citizen and the passport is expired. There are 3 directions before the learned single judge, your lordship, for the consent for the accused to give, your lordship. Despite these orders, the accused have not complied these objections, your lordship. And for the academic purpose, your lordship, all the documents has to be required, your lordship, for that passport to be renewed, your lordship.
No, my lord. Actually, I have already complied the form. The form, whatever they have submitted, that is 3053, and which is totally different. We have already complied the form of DS11, and DS11 is the renewal of the form. And in this form, that both the parents should be present in the US embassy where the passport has been renewed. Here, whatever the form they are asking me to consent, that is the 3053, that is only for the some conditions is there. And if the condition which has to be fulfilled means there is guardianship, if it is there, if there is any divorce or the father of the petition means child, they have the consent that he is not able to go to with the child. That is the form. But in the order, my lord, they never mentioned 3053 in the earlier, whatever it is, 18/9/2024, 13/8/2024. Only for 1/10/2024 they have mentioned. And this is the thing.
Yeah,
I have already complied for the DS11 form, and which is submitted before the trial court.
Your lordship, there are
On
2
39/2024.
One, both the parents have to appear before US consulate. One, when one party is not unable to appear. The both parents cannot appear together, your lordship. There is a criminal case against the father and the child is scared of the father. That is why there is another.
No, that is the disputed criminal case,
condition,
whatever
your
you have
lordship.
filed, that is a different
That is
different
where
issue.
the learned single judge told that to give consent for the DS form, DS 3053, your lordship. If I may
No, DS
permitted to pass
3053,
this,
because the
Your
Dharne
Lordship.
single judge is not give me the liberty to explain what is the 3053.
It is to give
I have already filed
consent.
a DS 11 form, my lord, as per the direction of the, and whatever the order passed by 13/8/2024, 18/9/2024, they have no mention. And they have filed an IA application and
Ultimately,
intimated
it
me
ha-
on
the passport
12
has
no,
to
no,
be
my lord.
renewed,
They
your
have
lordship.
intimated me on that day, that 12:56, you have to appear on 3 PM.
There are
I
three
cannot be appear on
directions.
that day.
There are three directions
No,
before the
directions, but
learns.
never mentioned in this direction, the 3053 I have to file.
If I
I
may,
have filed DS 11. What is the natural form?
your lordship, there is a particular directions before the learn single judge.
No, my
lordship.
Their
That DS
particular direction is 110. And they are not giving me
one
the
time
liberty
also
to.
there is a direction, your lordship. It has to be complied.
13/8/2024 and 18/9/2024, my lord mentioned that I have to consent the form. 13/9/2024 I have complied with.
Now
And
the
110/2024, they have come with the some IA application that I have to sign the 3053 form. I have.
Can we speak now?
Yes.
Which the directions are we complied with page 16?
page number 12, your lordship.
Page 20?
Uh,
16,
Page 16 relevant.
page 16. So you deposited the passport.
Yes, your lordship, we have deposited the
What is
passport.
the problem now?
Now, your lordship, the accused is telling they will appear with us with the US consulate for the renewal of passport, which is not possible, your lordship. Child is first scared of the accused, that is the father, and secondly, there is a criminal case against the father. So there is a second option, your lordship, where both the parents cannot unable to appear before US consulate, that is to give a consent. That for renewal of passport, they do not have any objections. That is where these three orders came to be passed, your lordship.
So give consent.
It
No,
is
no, we have
only for
already given a
renewal of
consent.
passport.
So we have given a consent for DS 11 form. This is not 3053.
DS 11 is to
My
appear
lord,
before US consulate.
3053 is a totally different, and I have challenged the order of the single judge, my lord, which is posted 24. Consent form I have already filed in 13/9/2024, but IA application they have filed for 3053, and 3053 is.
Page 20, DS 3050 form.
It is not given consent, your lordship. That is, they
Well,
are
3053 is
pressing that
different
they
because
will
as per
appear
the
with
US
us.
rule, that as per the US rule 3053, whatever, the both
If I
parents
may
has to be.
permitted to give the terms of US consulate.
Right.
Yes.
I have already filed whatever the rules and all that in my WA, my lord. So that is why I am praying before your lordship. 24/2, you can hear the matter connected with this matter.
Consent to DS 3050. Why?
3053 is a totally different, my lord. 3053 is that if I am not violating, then the US people will punish me.
You challenge
I have challenged, my lord, order,
in writ appeal, writ petition.
read appeal.
After service of this notice, they have
24/2, it is posted, my lord.
Posted. We will keep it after.
Your lordship, the issue is this, your lordship. Child school is pressing on APAR card, your lordship. That was supposed to be submitted before this December, your lordship. If I
My lord,
may permit-
2022, this passport expired. That point of time, the father initiated that you have to renew the passport. Several emails we have sent it, they will not do. Now they came up with this, that the urgency is coming. I'm
is
ready to, because
2
the
years,
father is
your
ready to
lordship, we
give the
have
consent,
filed.
but as per the rule.
It is since 2 years we are trying to get the renewal
2 years
of
we have
passport.
initiated in 2022. That point of time, mother is not cooperated.
Then they have challenged the in writ appeal, this part.
It is only after the notice.
My
they
lord, I have challenged because
your-
their rules is violating.
It is three directions to give the
Three
consent.
directions,
The
but two
only
directions
issue
is not
is
mentioned,
college,
3053.
school is,
3053, two directions is not mentioned. 110, when I complied, that day, after that day, they filed for I application, mentioned 3053.
it was
And they intimated
specifically
me
told to give
12:56 PM,
consent, your lordship,
appeared
not to
for 3 PM.
appear
I am
along
not
with.
able to appear on that
It
day.
is not to appear along with, it is only to give consent.
No,
It
no,
is,
no, why consent is given, that is why I have to explain, because 3053 is a totally different form.
Which form you will give consent?
My lord, 3053 means that there are some rules is there, that if the
those
father.
rules, if I
Just a
may
minute,
be
just a minute.
permitted to produce, your lordship.
I have already, challenge I have already produced in my WA. That is why I am praying before your lordship, please connect it, this matter on 24th.
Lordship, my only issue is this, your lordship. The college is pressing on the documents for APAR card. It was supposed to be submitted before December. They're repeatedly sending us the messages for
No, my lord,
the documents.
2022,
If I
when
may-
I am instigating that you please renew the passport and all those
Only
things.
issue
they are
is
not
between
ready.
husband and
That point
wife,
of
your
time, now
lordship.
the issue is coming for that. Initially, they have mentioned that they has to take a note, appointment for 4th. But second, they have 2nd of October, 9:24 PM, they are mentioning that their appointment is 4th, and that is in, the flight is 8:30.
That
So
is
they
because
intimated
two
me when the flight
directions are
goes.
given, your lordship. That is where we had
They have
filed.
intimated me when the flight goes after, that is the thing.
Your lordship, if I may be permitted to produce the
No, my
terms
lord.
and the
Give me the
documents.
opportunity to hear my WA and then. Because I am also ready to give the consent, but as a specific rule maintained by the US, whatever the rules is given. If the father is unable to give the consent, when means go to the US embassy, then the guardianship it is there, that is also rejected by the lower court. So there are three rules are there. So any rules is not permitting for 3053, my lord.
3053 is
3053
only,
I have
your
to sign
lordship,
then?
limited when the either of the parent is unable to appear.
Either of the parent, my father means the child's father is not unable because he is ready to go. But they are
The
insisting
only
in
issue is there
they
is a
insist me
criminal
to
case against
sign-
him and the
sign
child
because-
is not willing to
No, my
see the
lord,
father.
because there are also the order passed that visiting rights. They cannot give me allow me to visit my child. And after that, if they will take away, then what the father will do?
There is a criminal case against the father,
criminal
your
case, you
lordship.
have filed lots of cases.
And the
So
child
criminal case you can
herself is
file.
scared of the father.
No,
That
no.
is where the
No,
counseling
case
has
means
been
what? 3
directed.
years. If you inject me that your father is bad, then the child is fear.
That is,
3 years the father cannot see the child.
your lordship, that is
No,
why
no.
the counseling
What-
is
My
going
lord,
on.
my humble submission is that allow me to first WA, you can hear me, and then whatever the necessary order you have passed.
That will, but father is serving in army.
My lord.
Father is serving in army,
No, my lord, father is not serving that.
so aggressive.
The father is not seeing the child for last 3 years, my lord.
The appeal is
As
come.
per the visitation, we have.
A visiting right is there. I have already
Your
filed the
lordship,
contempt on
my
that.
only issue is that the college is.
So stated on behalf of the respondent that the writ appeal is filed in respect of to call in question one of the directions which is subject matter of the contempt petition. And that the said appeal will be posted on 24th of February.
24th.
To be listed along with to be listed on 24th.
Acknowledgement.
Grateful.
This is number 24. Mr. Sharath S. Gowda.
That's on offering for complaint notes. Complaint notes.
Complaint, what is it about?
This is for reply by accused one, madam.
Representation.
Please, minutes.
Certain my lords, as per annexure D on 19/7/2024, the special, the deputy commissioner has addressed a letter to Tashar to effect the kata into the name of the complainant, my lords, and ascertain and report on the next date of hearing, my lords.
So it is done or not? Decided representation to be considered
Please.
within 3
Consider.
months.
Thereafter, they had made an application, my lords, and subsequently on 19/7/2024, my lord, the special deputy commissioner has addressed, given directions to the Tahsildar to do the needful, my lords. I have to ascertain on this whether the Khata has been affected or not. On next date of hearing, I will report the same to this court, my lords.
Some order is, endorsement is passed.
I have to ascertain on that, my lords. Next date, I'll report the same, my lords, whether it's complied or not.
3rd of March.
Please, my lords.
On which date, learned, you report compliance. This
Please,
simple,
please, I report compliance, my lords, on next
3rd
date.
of March.
Please, my lords.
To be listed at 2:30, since learned additional government advocate will be reporting compliance of the order of directions of learners.
Twenty-five is urgent, seal number 26. Mr. Srinivas Murthy SR.
Proper the respondents.
26.
Endorsement has been given, my lord. The order was to conduct an inquiry and thereafter pass fresh orders. An endorsement has already been issued, my lord, to the.
So what is the inquiry? Is it entitled to salary, etc.?
The inquiry is held, my lord. Thereafter, the findings, after the findings, my lord, endorsement has been given saying that the promotions have already been given. And he has retired from service also. Accordingly,
It is produced on record. Endorsement is produced on record.
my lord,
Endorsement is produced on record.
I have produced the endorsement only, man.
Where is that?
My lord,
12/22/8,
Page 4 and 5, man.
4 and 5. And what is page 6 is also same.
4 and 5 is the endorsement given to the said complainants, man.
So nothing survives. You can challenge the endorsement. Who appealed?
He is not appearing.
Don't appeal.
That's all.
Keep
My
it.
25th. He is not appearing.
Or on 11th at 2:30.
For the complainant, my lords. My lords, the contempt in this matter instantly arose out of the accused mother failing to hand over the custody to the complainant, my lords. If I may take you to page number 43, my lords.
Appearing for the respondent, I'm undertaking to file wakalatnama on behalf of the respondent. The copy of the petition is not served on the respondent, your lordships. Only the notice was served through email. The petitioner may be directed to serve the copy of the petition. Your lordship.
At page number 43, my lords, the complainant accused have entered a joint compromise petition. Clause number C, my lords, the children shall spend the entire or part of school vacations with the respondent, my lords. What transpired, my lords, is that on 27/6/2024, my lords, the accused mother reneged on her undertaking, my lords, and failed to hand over vacation custody to the complainant, my lords. At page number 89, my lords, I have adduced the email, my lord, wherein the accused has reneged on her undertaking in the compromise petition, my lords. The complainant father has not seen 3 of 6 kids for the last 7 months, my lords. The eldest son resides with the complainant currently, and he has also not been able to meet his siblings for the past 7 months, my lords. My only apprehension is that if the accused continues to flout this order, the oncoming summer vacation also will not be able to see them, my lords.
Where is the order?
My lords?
Where is the order?
My lords, the order is at page number 43, my lords. It's a joint compromise petition entered into between the complainant and the accused. Clause number C at page number 43, my lords.
Page 43. Number 3. This, see, children shall spend their entire time,
Sorry, yes, certainly, my lords. They have not been able to spend,
part of vacation.
not even part, my lords. If I may take you to page number 89, my lords. This is the email sent by the accused citing that I have received I will not be sending Anaga, Jaya and Adya to India. That is the other three children that is currently residing with the accused, my lords.
Only children and mother and father are in USA.
Yes, yes, my lords. The mother resides in US currently, in New York. The mother resides in New York. Father is in India, my lords. My lords, moreover, I've although furnished the tickets and the nanny I would accommodated in order for the children to come over from New York to Bangalore, my lords. That is adduced at page number 83, my lords. The flight tickets.
Yes, madam.
Your lordship, in the same agreement, there is also a clause which says that based on the situation, the terms can be modified, your lordship. I have strong objections on the maintainability of the present petition and the trial court proceedings, your lordship, because all the parties are not Indian citizens, your lordship. They are US citizens.
Are we
And
my lords, if I may.
And your lordship, there is also a foreign court which passed an order in favor of the mother, your lordship, giving her the primary custody of the children. In fact, it is the petitioner who is defying that order, your lordship.
My lords, I've already secured an anti-suit injunction against the same order, my lords, filing an execution petition, my lords. Moreover, my lords, when the agreement and compromise was entered into a court before here, my lords, it would not make any sense wherein the New York court would have given an order against that, my lords. Moreover, my lords, I was in constant communication with the accused. If I may take you to page number 76, I've addressed the accused. Just wanted to confirm summer dates for the kids, round trip Boston to Bangalore and Bangalore to Boston, departure dates and departure back from Bangalore. The accused states, my lords, on page number 76, dates and names are good. I will fill out the sheet. The accused acquiesces to this, my lords. One day prior to the date of travel, she reneges on it.
My lords, the anti-suit injunction was filed much later after this injunction was passed by the courts in New York, your lordships. They've already granted a primary custody of the children to the mother, your lordship, because based on the sexual offenses, allegations on the father, your lordship.
You go to US or not?
My lords,
You go to US or not?
I do travel, my lords.
If there is if the respondent visits US, he shall have interim custody of the children. Where?
My lords, but then the children's roots are here. The children would like to see their grandparents, my lords.
My lords, in fact, the petitioner is a US citizen, my lords. He regularly travels to US.
Joint compromise petition was entered before a court of India, my lords, before Bangalore family court, my lords. I've accommodated for all the travel arrangements as well, my lords. I've arranged for the nanny to accommodate the kids from Boston to Bangalore and from Bangalore to Boston back as well, my lords. I only urge for a direction for the accused to comply with the clause. my lord.
Today there is a vacation in the school.
Not, my lords, oncoming vacations. I'm apprehensive that the accused will continue to flout the order, my lords.
So you want to enforce the direction for the next vacation?
Certainly, my lords.
When it is starting?
My lords, April.
April.
I may seek further instructions to that effect, my lords, but it's around April, my lords, as to when the summer vacations are.
My lords, I also want to bring it to the attention of this honorable court that there are settlement talks ongoing between the parties. In the meantime, there may be direction may be given to them to serve as a copy. We'll file our detailed objections, then the matter may be put up for the hearing, your lordship.
At the time of filing, I furnished sufficient copies.
There
as
was
well.
only, we received the notice through email, your lordship. It was only a notice copy, your lordship. There was no petition served on us.
I will very well furnish another set of copies.
See, counsel, this is to implement the compromise that was entered into between the husband and wife. You are bound by it.
Yes, sir.
In contempt matters, we will not, we are sitting as an appellate authority over here on what compromise that you have entered into. Question of re-examining the merits does not arise. The only thing we are looking into over here is, are you abiding by the compromise agreed upon or not? If you don't abide, then action will be initiated against you.
I'm completely bowing down to that, your lordship. My only humble submission is the children, the court order has been modified and all the children have been transferred to US. So the jurisdiction also vests with the US, your lordship.
That fails to be, my lords. The joint compromise petition was entered to here, my lords, before Bangalore, before the family court in Bangalore, my lords. That fails to be.
Page?
My lords?
Page?
My lords, the joint compromise decree, my lords, if I may take you to the decree at page number 28, my lords. Sorry, my lords, page number 34. The type copy is. The decree was before the third additional family court in Bangalore, my lords.
April, we'll see, April you have to be. File Wakalatnama will post on 11th March.
Yes, sir. We will duly file our Wakalatnama in the meantime.
My lords, if may be posted for a date in February, my lords, because I'm apprehensive.
Your lordship first.
Sorry, my lords.
4th March.
4th March.
Learned request, so and so appear to respondent and wants to file Wakalatnama, she is permitted. Full stop. Petitions will be listed on 4th March. So you have to comply with, as my brother rightly says, you have no option but to comply with.
We will convince your lordships on that, your lordship.
Always.
Number 28. What?
For the complainant, my lord. My lord, there is a direction to comply with the Lalita Kumari versus State of UP, my lord. As per Lalita Kumari versus State of UP, my lord, para number 120 clause 2 specifically says that police officer cannot avoid his duty of registering the offense of a cognizable offense, my lord. My lord, my complaint, my lord, discloses cognizable offenses. It is that, my lord, they have morphed my video, photos, and circulated in WhatsApp, my lord. Now, my lord, that is an offense under 336 clause 4 of DNS, my lord. Clear, that is a clear case of non-cognizable offense, my lord. Yet they have given endorsement once again that it's not a cognizable offense, it's a non-cognizable offense. And they have issued notice to me saying that you provide some of the materials, my lord. Under CRPs, my lord, they have power to secure materials, summon the documents, my lord. I don't have power to summon document. They cannot simply say that it's a non-cognizable. It's clearly my complaint discloses cognizable offense, my lord. Punishable under 336 class 4 of BNS, my lord. Because forging the document in an electronic format with an intention to defame me. Earlier under IPC, my lord, defamation, I have to file a private complaint. But under BNS, my lord, 336 class 4, electronic evidence is used, forged document is used for defaming any person. That is an offense, my lord. May I read 336 class 4, my lord? 336 class 4. My lord, whoever commits forgery intending that the document or electronic record forged shall harm the reputation of any party, or knowing that it is likely to be used for that purpose, shall be punished with the imprisonment of either description for a term which may extend to 3 years, and shall also be liable to fine. Therefore, my lord, any morphing of document, forgery of electronic evidence with an intention to defame any person, it's a cognizable offense. Lordship may kindly see my complaint, my lord. It is at page number 21, my lord. Typed copy is at page number 21, my lord. It's a typed copy, my lord. My lord. Malicious exploitation, second para, my lord. First, Sunil Kumar. He has filed against his political rival, my lord. He has circulated everywhere, showing that I have been arrested in bribery charges, my lord. That is the circulation he has committed, my lord. My lord, second para, malicious exploitation of these forged and morphed photos and videos, along with their dissemination and WhatsApp group, has severely tarnished my reputation and caused significant harm to my standing in the society. Such heinous acts are not merely derogatory, they represent a calculated attempt.
Where is that? What endorsement you made?
My lord, your lordship may kindly see in their affidavit they have stated,
Complaints affidavit is filed
saying
on-
that it's a non-cognizable offense. Endorse. My lord, endorsement given by police is at page number 25, my lord, which says you give us the documents and materials, my lord.
Page number
25, my lord.
25.
Yes, my lord, please. Of my petition, my. They say, the last para, my lord, they say, the complaint and associated documents you have provided currently do not contain any information regarding cognizable offense. If you possess further details or evidence related to cognizable offense, you are requested to provide the same. Lordship, may kindly smile. I have to set complainant has to set a law into motion, my lord. Thereafter, based on after registering a FIR, they have to inquire by seizing the relevant documents, my lord, materials, my lord, and electronic devices. They have to seize and secure the additional evidence. At the time of complaint, my lord, even I don't have power to seize anything from the accused person. Therefore, he say there is no complaints of Lalita Kumari versus state of UP, my lord. Therefore, they have to register FIR, my lord.
What is page 30?
My lord, my lord. That is another endorsement they have given, my lord. There also they say, yes, you have to provide additional evidence. Additional evidence, prerogative of the investigating officer to collect, my lord. If I have any document, I am ready to give, my lord, but it's not in my, I don't have power to secure. Therefore, I have to.
You take instructions for.
My lord, complaints affidavit is filed on 26th October 2020.
There is no proper complaints, my lord. They have filed. They cannot say, in cognizable cases, they can say it's a non-cognizable.
On which date?
26th October 2024, the compliance
26th
affidavit is
October.
filed. And your lordship may kindly see, my lords, page number 8 of my compliance affidavit. Subsequently, orders passed by the learned single judge, my lords. We have written a letter, we have communicated to the complainant, my lords, calling upon him to give certain things. For a moment, my lords, the type copies at page number 12, my lords. There are 3 communication letters have been made by the jurisdictional police, my lords, to the complainant, but none of these letters, my lords, has not been responded to the same. The translated copy is at page number 12, my lords, may permit read the last paragraph, my lords. Last but one. Further regarding this matter, the Honorable High Court of Karnataka, Bangalore was dealt with Honorable WP number so and so. Therefore, the petition is disposed with directions to the respondent 3 to 10. Consider the complaint filed with the petitioner as per Annexure A in the context of so and so case to take appropriate action within 1 week from the date of the receipt certificate of the order. In the complaint filed by him and the documents related, there is no information about the crime. If you have any further information regarding this complaint, you are requested to provide the same. That is on 27/8/2024. Subsequently, one more letter was issued on 1/9/2024. Subsequently on 14/9/2024. For none of these communication letters, my lords, is not responded, my lords.
My lords, I have page number 30, my lord, I have responded. Each and every letters I have responded, saying that what are all the documents I have submitted. These are all circulated in the WhatsApp groups, my lord, for which they have to collect the evidence, my lord, during investigation, my lord. Under 91 CRPC and 102 CRPC, they have to collect the records, my lord. It's not in my, they have the prerogative to collect materials during investigation.
So page 18 is there.
My lord, they have written, but my submission is that, my lord, the complaint discloses a cognizable offense, my lord, of 336 class 4, which is a cognizable offense, my lord.
Police are
Instead of that, just to support the accused, my lord, because it's a political matter, the accused belongs to ruling political party and I belong to opposition party. That's the only reason, my lord, they are supporting the accused, my lord. Otherwise, it's a clear case of a cognizable offense. They are duty bound to register FIR as per Lalita Kumari versus State of UP. May I submit Lalita Kumari judgment for a while? Para number 120. My lord, 124, your lordship, may kindly see. The police officer cannot avoid his duty of registering offense if cognizable offense is disclosed. Action must be taken against erring officers who do not register the FIR if information received by him discloses a cognizable offense. My lord, he has to register FIR, my lord. And your lordship, may kindly see 120. The register 120 class 1 registration of FIR is mandatory under section 154 of code if the information discloses commission of a cognizable offense. And he has to inquire only whether it falls under the category of cognizable or not.
Defamation, no?
My lord,
Purely
defamation is
civil
also, my lord,
civil dispute, my lords. If at all, they can file
May-
original suit.
Now, what is meant by Sangneya and Asangneya?
ಸಂಜ್ಞೆ ಅಂದ್ರೆ cognizable, ಅಸಂಜ್ಞೇಯ ಅಂದ್ರೆ non cognizable, my lord.
Kannada translation.
My lord, Lalita Kumari versus State says that if it is a cognizable offense, you must register a FIR.
Now, defamation, is it a cognizable
My
offense?
lord, this is not only defamation, my lord. This is, my complaint is that, my lord, my photos and videos he has morphed, forged, and thereafter circulated. Therefore, forgery is also, there is an element of forgery, which is a cognizable offense. Forgery, my lord, 330, under BNS, my lord, it is 336, class 4, my lord. I may be permitted to read 330, section 336, class 4 of BNS, my lord, which is clearly attracted. I may be permitted to read, my lord.
Whoever commits forgery intending that the document or electronic record forged shall harm the reputation of any party or knowing that it is likely to be used for that purpose shall be punished with the imprisonment of either description for a term which may extend to 3 years and shall also be liable to be fined. And as per BNSS, my lord, it's a, my lord.
Where is forgery over here?
My lord,
It's sending a WhatsApp message which according to
not only WhatsApp, creating video, morphing the video, and it is a forgery of electronic evidence document, my lord. Therefore, it's a forgery, my lord. Otherwise, I wouldn't have. He has created, my lord, my photos, my lord. I was previously
It's
minister.
not forging a document, sir.
My lord, forgery. It's a, he has twisted. He has morphed my videos as if like I'm locked in the police station. I'm locked in the jail. That is the reason. That is forgery. Clear case for forgery.
It's not forgery. It's
My lord, your lordship may kindly see.
it may amount to defamation. That's all.
Lordship may kindly see forgery. Definition of forgery I may be permitted to read. Whoever makes any false document or false electronic record. It's a false electronic record, my lord. Showing, my lord, cutting and paste of my photos, lordship, cut and paste of my photos inside the jail, showing that I have been arrested by police. Police are holding me. All these are forgery, clear case of forgery and that's my lord, morphing of the videos, my lord, that is clear case of forgery. If it is defamatory, yes, my lord, I would have filed a private complaint before the magistrate. I have no other. This is not only defamatory, my lord. Forgery with intention to defame. My lord, 336, it's a new, it is come, first time it has come in BNS, my lord. I mean, BNS, it falls under 336 class 4 of a BNS.
BNS is good.
Yes. BNS. May 36. BNS. My lord, 336 class 4, my lord.
And the schedule of a CRPC says that 336(4) is a cognizable offense. Your Lordship. Okay. So. CRPC schedule. Bharatiya Nyaya Samhita schedule endally. Endally. Sorry, schedule 336+4. Endally, correct.
It's a created document. I mean, it's a created electronic record. You can't term it as a forgery.
My lord, created, yes, sir, created. Your Lordship, may kindly see the definition of forgery, my lord. My lord, 336, whoever makes any false document or false electronic record, my lord, false electronic record, or part of a document or a electronic record with the intent to cause damage or injury to public or to any person.
Now, first you have to satisfy the definition of forgery.
Yes, my lord. Your Lordship, may kindly say 336, my lord. May I read, my lord? Whoever makes any false document or false electronic record. My lord, it's not a true electronic record. It's a false electronic record. The photos and videos showing that I've been taken by the police. I've been dumped in the police van. I've been kept under police custody.
My lords,
Definition of forgery is.
complainant says that it's a forgery. To establish a forgery, my lord, there must be a original document, my lord. Tampering of the said original document amounts to forgery, my lords. Now, what he says is that a videos has been made to reflecting or showcasing that so and so person is behind the bars or whatsoever. That will not amount to forgery, my lords. Forgery is what? It is tampered to the original one.
My lord.
That will not amount to any forgery, my lords.
They
If
have to
that is the case,
investigate.
my lords.
My lord, root of the video, my lord, root of the document, they have to investigate, my lord.
We'll hear
Please, ma'am.
7th March.
Please, ma'am.
Number 29.
Much.
Lord, I am for the complainant. We beg to withdraw the contempt, Lord. The learned single judge's order is modified. My colleague is there with the withdrawal memo.
Learned docket Miss so and so. Hearing for learned advocate Mr. Sridhar Prabhu, who appears in video conferencing. You are Aishwarya Chandran.
Please, my lord.
Learned advocate Miss Aishwarya Chandran appears. Learned advocate Mr. Sridhar appears again. Learned advocate Mr. Sridhar Prabhu appears for the complainant appear through video conferencing, assisted by learned advocate Ms. Ishwarya Chandran, who is present in the court to submit memo of withdrawal dated 7/2/25. The same is taken on record for the text stated therein. The leave to permission to withdraw the contempt is granted. Petition is dismissed.
Great.
Thirty is urgent, seal number 31. Jagan Mohan MT. Seal number 31.
Sorry,
You are in third.
I was not aware, man. I've been waiting from 10:30 for the matter. I was not.
Urgent.
Urgent.
Any short, I will only request one of the short.
Which date is given?
21st March.
Is it possible? Because it's a dispute between a father and a son. Son is terrorizing the father. There's a order of stay, my lords, because my lords were looking at resolving the matter through mediation.
You are for complainant.
Yes, my lords, I'm for the father, my lords, I'm for the father.
Complainant.
Complainant, yes, complainant.
So when shall we?
No,
25th?
I'm for the respondent, my lords, respondent. I'm for the respondent. The stay order is operating against me.
Stay is open.
I had made the complaint before the commissioner, assistant commissioner, who's passed an order in my favor. Writ petition is upheld.
6th of March.
Wait for this.
Inform the other.
I'll inform.
December 31, Mr. Jagan Mohan MT. Writ petition PA.
Pass over.
My lord, notices have been, services awaited, my lord, in respect of respondents 1 to 9. I take notice for respondents 1, 2, 3, and 6.
The endorsement on the board shows that respond 1 to 9 are not served. As the notice, as service of notice is awaited. Post of power, learned additional advocate is, additional government advocate Srimati Nilofer Akbar appears to submit that she accepts notice on behalf of respondent 1, 2, 3, and 6.
Yes.
Most of rest of the respondents shall be served, for whom fresh notice shall be issued returnable on 20th March or 24th March.
Still number 32, Mr. Ramesh Nayak N.
I'm for the petitioner, my lords. Memo for withdrawal has been filed in. I filed a memo for withdrawal, my lords.
Memo of withdrawal.
Yes. This petition was initially filed as an ordinary writ petition, my lord. Later it's been converted into PIL. So I filed a memo for withdrawal as I couldn't find a proper material. And also the memo for disposal also. The petition was initially filed as an ordinary petition, my lords. Later it's been converted into PA. So I couldn't find a proper material to defend the case. So I filed a memo for withdrawal and also disposal also. The matter earlier listed before this bench first time, 4 to 5 occasions, but it could not reach me. So I filed in a March itself, March 2024. For withdrawal.
Learned advocate for the. Your file your response.
Report, my lord.
My lord, I appear for respondent number 4, my lord.
Earlier also you filed that.
It pertains to granting of land for solid waste disposal, my lord. Copy has to be served on me, my lord. I have entered appearance, but writ copy has not been served on me, my lord.
Let division permitting you withdraw. Just look into it.
My lord.
Learned assistant, learned additional government advocate, Ms. Nilofer Akbar will apprise the court about the controversy which is involved in this public interest petition. Stand over to. 17th March.
Number 33. Ravindra Kajanan Kolde.
For the petitioner, my lord. I request weeks time to take fresh steps to issue notice to respond number 4, my lords. Respond number 4 is remained unserved.
Press notice you want?
Yes, my lord.
Press notice to respond for returnable on 21st March.
Only in respect of respond number 4, my lords.
So number 34.
34.
Office objection for second time.
For petitioner in this case, my lords, I placed 2 weeks time for office
4
objection,
weeks.
complaints of office objection.
Failing to remove the office, failing which the contempt petition shall stand dismissed. The reference to order of the court.
For fourth time, say number 35, the KR Satish.
35, 36,
2 weeks time.
37, 38, 39, 40.
36.
To 40, same order, 3 weeks. Then 42, same order for 2 weeks.
43 is disposed. So 44, office objection with council submission.
I appear for the petitioner in this matter, my lords. My lord, the objection raised by the registry was with respect to why respondent number 2 to 4 have been arrayed as a party to the present contempt petition, even though there's no specific direction against them. If my lords may take page number 14, my lords.
What is that objection?
My lords, the order itself, the objection is that why have the respondent number 2 to 4 are not necessary parties since there's no direction specific made to them. As per the impugned order.
This objection is dispensed with.
Please, my lords. My lords, shall I proceed with hearing? My lords, this is a order passed against the
Listed on
BBMP.
3rd March.
Please, my lords, I'm grateful.
45. The Prasad KR Rao. Office objection with council submission.
Next.
46. To Bala Nikit.
For the petitioner here.
My lord's, office objection is raised with respect to why accused number 2 was made a party, while he was not a party in the WP. My lord's, annexure D in page number 58, there's a clear direction against respondent 3 therein, who was HESCOM, represented by its managing director, but the direction was to release funds to make payments. Now payments are due, and hence this contempt has been filed. Now, the person responsible to have released the funds should have been the financial head for HESCOM. Hence, to take abundant caution in this matter, we've made him the party. Hence, he is made a party, or he's made as accused number 2 in this.
So,
That's all, Your Honor.
so what is the objection?
Objection is that he is not a party in the WP.
Why you are joined?
We made him a party is because orders were essentially against respondent 3 there in the WP, which is the HESCOM. And the direction was to release funds to us, to make payments, payment of funds, to make payments, and the payments are due. Because these funds had to essentially be released by the financial head, which is accused 2 in this. Hence, we've made, to take abundant caution, we've made him as a party in this.
Contempt petition shall be listed irrespective of objection, subject to further orders, on 24th March.
Number 47. Akash.
Now, in this, the office objections, why is A5 made a party? A5 is RERA. There's no specific direction in the particular judgment for saying which there's a contempt. However, since they're party in the mandamus, I have made them a party here as well. So that is the only office objection which is there, that why RERA has been made a party. Because they are party in the mandamus, even though there's no specific direction, because we have challenged the because non-compliance of RERA orders. That is why RERA was made a party there as well.
Which objection regarding A2 is made is about A2 is made party is dispensed with. Second petition will be listed on 7th March,
Number 40,
12th March.
number
There is no direction issue to.
Why you are joining RERA?
my lords.
Why you are joining RERA? This part?
Because they're part of the mandamus also. In the mandamus petition also, they were part of the thing in the judgment. There's no direction against RERA.
Then you can
I'll delete them.
advocate.
No, my lords, my supposition is that because I'm relying on some certain documents from RERA, there because the builder against whom and the DC, they've not taken the action is the biggest defaulter, my lords. So even if RERA is on board, if some direction, because this is more than a control, is actually a more in light of a PIL, my lords, if I may add this. Because today, close to 850 crores is due to the home buyers because inaction of the DC and Tehsildar. And these are 47, 48 is a similar matter, connected matters, my lord, in the same group. So even if RERA is there as a party, you can hear them.
To be listed on when? March 12.
48 is also the same.
48 is so.
Yes.
What's
48, I made a build. They've asked why the builder has also been made a party because it's his properties that we own.
respective of his officers, it shall be listed on
Same,
March
12th March.
12.
number 49. The Shobha S. Bhavikati.
Appearing for the appellant in this matter, my lords, wherein the office objection raised was certificate of registration of apartment association, my lords, wherein I have furnished a deed of declaration executed under the proviso of Karnataka Apartment Ownership Act, my lords. That deed, which states that the association has to be formed. That is the mother deed of the said association, my lords. Already it has been furnished in page 138 to 229, my lords. Hence, it might be dispensed with, my lords. In respect of office objection raised in number 2, already I have filed a memo of complaints along with the postal acknowledgement, my lords. Hence, I have complied with all the office objection. No.
Listed on 21st March.
Number 50.
I appear for the appellant, my lord. The office objection is with regard to a typed and translated copy of document number 4 produced along with the application, my lord. That document are only some newspaper publications which we have taken and we're not relying on that. That is the council submission, my lord. Since there's an urgency in this matter, if I may be permitted to make submissions as an application for stay.
50.
Yes, my lord.
You're in 50? Which serial number?
Serial number 50, my lord. Serial number 50.
Learned advocate Miss
Rupa Roan.
Rupa Roy.
Yes, R-O-N Roan.
RON. States that
The office objection is with regard to a typed and translated copy, my lord, of document number 4, which I have produced along with my IA. Those are only newspaper publications issued
that
under
the
the SURFACE Act, and we're not relying on them.
heard learned advocate Ms. Rupa Roy. The office objections are dispensed with. Appeal shall be listed on
My lord, there's an urgency here. There's a stay application, my lord. I'll just take 5 minutes of the court if I may.
6th of March.
There's a stay application, my lord. The secured asset, we have taken possession of it, my lord. I'm a banking company. I've taken possession of the secured asset. And there's a third party who comes and files a writ petition claiming that he's the owner of the property, my lord.
We listed.
And the learned single judge has ordered the possession to be handed over to him.
We'll take up on 6th March.
6th March.
Number 51. The Nayana Tara BG.
My lords, I appear for the appellants. The office objection is with regard to impleading R3, which is state, my lords. But it's due to some inadvertence in the order. R3, the state is in fact not a party to the writ.
My only respectful submission is the state is a party. Lordship to kindly see the impugned order. State is a formal party. They have been impleaded.
In the order, it's crept in by inadvertence, my lords. If you can turn to the, if I may kindly ask your lordships to turn to the writ petition itself, they're not a party in it.
On page
But impleaded by.
45, my lords, where the writ petition itself is, only two respondents being the registrar and union.
Or let office of
Fine.
dispense.
My lords, the matter may be kindly passed over. My senior would like to argue for an urgent interim relief, my lords.
No, it will be listed. When shall we list? 24th?
It may kindly be passed over, my lords, and shortly.
No, no pass over. We listed on 24th February,
20th, my lords. 20th kindly, my lords.
20th.
20th.
I'm great.
So let's-
Number 52. Alvin Sebastian. Number 52.
What? 53.
And all this may be called next week, my lord. I'll just verify as to what is the, where is the elephant, my lord? This is with regard to a missing elephant. The elephant is in a mud, but there is some dispute with regard to that
We'll
and
find out the missing elephant next week. Next week, little later. 11th March.
apply.
Number 53, Jagdish Acharya.
Respondent number 5 and 6, my lord.
Pardon?
53.
53, Mr. Jagdish Acharya.
He's not here. Wait, what is it about?
My lord, demolition of an apartment which is constructed on government land and encroachment of Raja Kaluwe, my lord.
Office of Business regarding color photography is dispensed.
Number 54,
Lord, in
Ajay Rao.
Office objections, my lord, are that, my lord, there are two documents which are in Kannada, my lord. We are not relying upon it. My lords may, my lord, dispense with them, my lord. In this case, my lord, what has happened is there was, my lord, a pollution control board. We filed an application, my lord, we have been running the factory for the last 50 years. There's been continuously, my lord, pollution, my lord, consent orders. We filed an application for renewal. My lord, after 8 months, now they say that, my lord, we had asked you to do this. That is, my lord, they said that, my lord, we had asked you to give an affidavit. We gave that affidavit. Other than that, there is nothing else, my lord, that they have said. They now say that it is rejected after 8 months. My lord, there's a deemed, my lord, permission. Can I persuade your lordship? Just look at, my lord, two judgments of this honorable court. Ready? Under almost identical set of circumstances, my lord, this honorable court has held.
So some report is of June.
My lord, the order, my lords get that, my lord, at running page.
Inspection of the industry on 27 June 24.
My lord, thereafter, my lord, we have been running it because, my lord, when the application is pending, my lord, we continue to
Thereafter
run.
you are running.
Yes. My lord, please have a look at this judgment. Deemed, my lord, approval. Please look at the last judgment, my lord, page 38.
Which judgment?
38, my lord, 38. Paragraph 2, my lord, at running page 40. My lord, I'll skip all that, my lord. Para 12, my lord, at page 45, my lord. I think that is more than sufficient. Para 12 at page 45. Claim of the petitioner in the present case, sorry. Claim of the petitioner in the present case is that there's a deemed consent is based on the provision contained in subsection 7 of section 25 of the Act. Section 7, subsection 7, which deals with the deemed consent, is reads as under. Consent referred to in subsection 1 shall, unless given or refused earlier, be deemed to have been given unconditionally on the expiry of the period of 4 months or the making of an application in this behalf. complete in all respects to the board. Under subsection 7 of section 25, an applicant has only to satisfy the three factors, my lord, that, my lord, he consent, my lord, he makes an application, it is either refused or given, 4 months have expired, and, my lord, the application should be complete in all respects.
So your application is pending.
Everything, my lord, what they do is, 8 months, my lord, they keep it. Now, my lord, after 8 months, they say it is rejected. Or identical set of circumstances, well, in this case, please come to, my lord, running page 19. Sorry, 11, para 11. Previous page. Consent, my lord, whether deemed consent, my lord, that question of law, my lord, is in the previous page. Whether deemed consent as contended by the petitioner. Please come to, my lord, paragraph 19, 18 and 19 at page 48. 48. I am constrained to remark on this respect because the learned counsel of the board sought to justify the impugned order and the appellate authority on the ground that the petitioner cannot claim stake claim to the benefit available under subsection 7 of section 25 because the application was not completed. There, my lord, they said the application is not complete. In our case, that is also not the contention. When the board itself in its order refusing permission did not mention this aspect, it's not open to, in the light of the decision of Mohinder Singh Gill's case for the board or even the appellate authority sitting in judgment over the board to now turn around and make out a new case altogether and reinforce the order with a fresh, sorry. Para 19, sorry. Online application was filed by me, my lord, on 24/5. Hard, my lord, hard copy also we have placed before your lordship, my lord, please come to, my lord, page 50. On 25th of June, 2024, we filed this application. Rejection, my lords, get that at, my lord. In fact, my lord, it was served on us, my lord, day before yesterday. Please come to, my lord, running page.
Will issue the notice?
Please, my lord.
Notice.
Only thing is, my lord, 1,000 people are working.
They have
There's a deemed, my lord, the consent given, my lord. There are 2 judgments, other judgment of the Supreme Court also, my lord, which I have kept for my lord's consideration. In fact, my lord, under almost identical set of circumstances, this honorable court has been granting interim order of stay of the impugned order, my lord. Because admittedly, my lord, after 8 months, my lord, this rejection is covered by the judgment of this honorable court. Supreme Court also has held, my lord, that when there's a deemed consent or approval, it should be, my lord, given full effect.
under section
My lord, 12(7), my lord.
12(7) of lie.
Sorry, 25(7), my lord.
25.
Water pollution control. Water Act. My lord, it is culled out, my lord, in paragraph 12, my lord, which I just have now pointed out, my lord. Please come to, my lord, running page. 40, my lord, 7. Sorry, 45. 45, my lord. Claim of the petitioner that in the present case, there's a deemed consent is based on the provision contained in subsection 7 of section 25. Subsection 7 reads as under. Consent referred to in subsection 1 shall, unless given or refused earlier, be deemed to have been given unconditionally for the expiry of the period of, on the expiry of period of 4 months, for the making of an application in this behalf, complete in all respects. Therefore, my lord, in paragraph 19, this honorable court has held, my lord, that there is a deemed consent, and therefore, my lord,
U25(7). Of which act?
section 25, subsection 7.
It was filed on 25/6.
And my lord, refusal is, my lord, in January 2025, my lord, after 8 long months.
Where is the refusal? That's impugned order.
Page 73, my lord, at the top, my lords get that. 29/1/2025. After 8 long months. Therefore, my lord, it could not have been, my lord, rejected at all. Thousand people are working last 50 years, my lord, and we have, my lord, the NCLT also has passed a moratorium.
Third learned senior advocate Mr. Withdrawal, assisted by
Ajay Ram, my lord.
Both are same for the petitioners. The challenge in this petition is addressed to order dated 29th January 25. Passed by the competent authority of the Karnataka State Pollution Control Board, whereby in exercise of powers under section 25(4)(b), small b, read with section 27(2)(b of the Water Integrity Prevention and Control of Pollution, Bracket or Act 1974. The board has refused the consent for operation. For carrying out of the manufacturing activity. Full stop. The order appears to be based on the report of the inspecting team, which visited the industry on 27/6/24. From the record paragraph, it appears that from the record, it could be demonstrated that the petitioner had submitted its application for seeking consent on
25/6/2024.
Where is that?
Page 50.
25/6/24, which is referred to in the impugned order. Full stop. It was submitted that 8 months have passed since the making of the application under section 25 of the Act. Full stop. Learned senior advocate relied on the provisions of section 25 of the Water Act 1974 to highlight the provisions of subsection 7, which reads as in subsection 7 of section 25, which reads as in what subsection 7 only. On the basis of the above section, it is further submitted that the provision creates a deeming fiction, and the application made under subsection 1 is deemed to have been granted upon expiry of the period of 4 months. It was submitted that in the present case, 8 months have passed. Therefore, the deeming fiction will operate, and the consent is deemed to have been granted, entitling the petitioner to continue the operations. Paragraph. Notice to the respondents returnable on 11th March.
Please.
There shall be add and relief in terms of paragraph. Where your page? Read
26. Interim prayer, my lords get that at my lord 26.
Full stop. By way of add and relief, it is directed that the petitioner industry may continue its
Please.
operations till the next date.
Please.
subject to further orders.
Next matter also similar, my lord. Same duplicate order, my lord. Next one.
Your lordship, I'll take notice for the board in both the matters.
Net
your lordship.
advocate Ms.
Rishika Vaishnav for A. Mahesh Chaudhary, your lordship.
Shika Vishnu accepts notice on behalf of respondent number. Which number? Pollution Control Board. Whereas learned additional government advocate Srimati Nilofer Akbar accepts notice on behalf of respondent number 1. Please, the rest of the parties will be served. We'll say that if you are creating pollution, then they may take.
My lord, definitely, my lord. My lord, I would never, my lord, create pollution. Been running it for the last 50 years. Dry industry, my lord. It's not even a wet industry.
Sir, there has been a specific finding against you. Please come to page number
My
74.
lord,
and
I have
75.
no problem, my lord. You can impose a condition that I will not create. Please, I will, my lord. Obey, my lord.
No.
I can't.
Specific findings, sir, in page number 74 and 75. In the
Yes, my
impugned order, if you look at it,
My lord, all these are, my lord, pertaining to the year 2012-13. My lord, we have thereafter, my lord, they have given consistently every year, my lord, they have been giving consent. All these, please look at it, 73, 74. And then, my lord, what is the condition imposed? That you will not manufacture formaldehyde. I have given an affidavit even before this. That is also, my lord, not considered. Please, my lord, your lords may, my lord, impose that condition. I will not create pollution. Please, my lord, I don't want to, my lord, create any pollution. Please.
This order, this order shall not
Entitle the petitioner to create pollution.
preclude the
Please, my lord.
respondent authorities to initiate action for breach of any other pollution law.
Please, my lord, grateful.
If so,
Please,
if the circumstances, other pollution law,
please,
in accordance with,
please.
if so advised.
Grateful.
Obliged.
This matter also similar.
Do you have one?
Same order, my lord, duplicate order for Air Act. Grateful. That also
Objections in the beginning, office objections are dispensed with.
There is one.
Pass
Your
over
lordship.
matter,
Yes, lordship.
bill number 2.
Serial number 38 and there is a submission. Serial number 38 and 40, I'm filing wakalat on behalf of the respondents.
Bill number
38 and 40, it was not called out because non-compliances of office objection was this, that's why. Please kindly post it on 27th of kindly post it on 27th of February because yesterday also the case was connecting to that case was posted on the same date.
other cases are posted.
Yeah, yesterday it's
27th.
also. Kindly post it on to
38 and 39.
27th of February, sir.
Which number? Serial number?
Serial number 38 and 40.
38 and 40. All
Yeah.
38 and 40.
Highly obliged.
The pass over matter, bill number 5.
Here
Mr.
for
R.J. Hegde.
Sorry, my lord, I was not present when the case is called.
Delay is there. Delay. Notice returnable on 21st March, 25th March.
Bill number 17. Bill number 17. Mr. Jay Prakash Reddy.
Let it be on 7th, on 25th March. None present for the petitioner on both the calls.
42, 2 weeks time.
Granted, all office objections.
My lords, serial number 52, my lords, can it be passed over to 3 PM, my lords?
What is?
It was called out before I could reach.
No pass. What is it?
Serial
PIL.
number 52, PIL.
My lord, it's adjourned to 11th of March. Missing 11.
It may be passed over to three P M.
Pass or not. passed. If you want earlier date, it can be given.
Earlier date, my lord.
When shall we keep?
Monday, my lord.
No, not. 20th February.
ಇದು ಕೊಟ್ಟಿದ್ದಾರಲ್ಲ ಎಲ್ಲ ಟೈಮ್ ಆಗಿದೆ 40 to 19 March 19 ಹೌದು
The serial number 53, sir.
2 weeks ಅಲ್ಲಿ ಮಾಡಲಿಲ್ಲ ಅಂದ್ರೆ ಡಿಸ್ಮಿಸ್ ಆಗುತ್ತೆ
Sir, serial number 53, sir.
ಅದು 19-3, sir.
ಹಾ
ಈಗ ರೆಸ್ಪಾಂಡೆಂಟ್ ಕಡೆ ನಮ್ಮಿಂದ ಕ್ಲಿಯರ್ ಸರ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಕಡೆಯಿಂದ ಕ್ಲಿಯರ್ ಆಗುತ್ತಾ ಅಪ್ಲಿಕೆಂಟ್